Good morning.
Good morning and Happy New Year.
Happy New Year.
Happy New
Happy
Year.
New Year, sir. Yes.
Well, look, I just want to trouble one matter.
Yes.
I have no trouble with hearing of this matter, but there was some urgency in matter. So this IA we have filed, item number 4. Or
Item
orders,
4.
item number 4.
Okay, criminal petition.
Yes, we have filed an IA.
When?
Because
When?
Today, just now.
Oh.
So I have no trouble with hearing because that can be posted on 19th also.
It can come up on
Yes.
Monday also.
Yes, 19th. That's why I'm in trouble. Why this IA has been filed? Because there was no order from this court that my statement may be recorded because I am in US virtually. So I will show it, my lord, the matter come and why there is an urgency, so that it can be posted on 19th. So
Okay.
this matter may be brought at a time when the matter is being taken by.
Already filed.
Yes, it's on the process of
Yes,
time.
just tell them to send it up, the IA, okay? Okay, you wait for the turn.
Yes.
It will come up just now. Yes.
Yes.
Make clear.
Yes.
Okay. My matter was listed as item number 35 of the previous cause list. Now today morning the cause list is revised. It was listed as 35 item number. Therefore, can this matter be listed on 29/1? Because today it will not come because it is delisted now.
No, but when the matter is not in the list today, how will the other party know? How will the other side know about the
On
listing?
16 it was listed, but this morning it is the list is revised.
No. I don't think there was another list. Was there another list? This is the only list, 16-1. There was no other list, isn't it? No. There was no other 16-1 list. This is the only one.
I'll confirm.
Yeah, you confirm it. Yes. Yes, go.
Deeply upset.
For admission, item number 1.
Yes.
May I please, Your Lordship?
Affidavit in reply not filed.
Lordship, we have filed this morning.
Okay. Served copy.
Yes.
You've received. Miss Rebecca.
Yes.
Rebecca, learned counsel for the petitioners present, and submits that the affidavit in reply has been filed by the petitioner this morning, and a copy of the same has been received by the government advocate, Ms. Pichano Kitan, as well as the counsel for the private respondent, Mr. James Newmy. So accordingly, list the matter. Should we list it for hearing?
Yes.
If pleadings are complete.
Yes.
Accordingly, the pleadings are complete and therefore list the matter for hearing in usual course.
For admission, item number 2.
This Lordship.
Yes.
Lordship, I'm mentioning on behalf of Gauhati for respondent number 1, Your Lordship. Your Lordship, in this case, we are going to file our affidavit. How about your
Who's
Lordship?
respondent 1?
For a union, there is for the finance, Ministry of Finance, Your Lordship, as long as concerned with this matter, Your Lordship, the union does not have much more to say on this, Your Lordship. It's concerned with the state
It's
government.
actually R2.
Yes, Your Lordship.
It's a DRI case.
Yes, Your Lordship. Yes, Your Lordship.
If it's a DRI case, then the respondent number 2 is the main respondent.
Yes, Your Lordship.
You're appearing for R2 also?
No, Your Lordship. Only for R1, for the
For
respondent.
R1. Then notice on R2.
Your Lordship, we have already served the notice.
Standing counsel. But none appeared because on 10/12/25, when the matter came up, the order says no one represents the state respondent, the Union of India, as well as respondent number 2. Although it is submitted by the counsel for the petitioner, that copy has already been served to the CJC as well as learned standing counsel for the respondent number 2. Who is the standing counsel for respondent two? No, you're saying you have served copy to learned counsel for R2. Directorate of Revenue Intelligence, Dimapur. Any idea who's the standing counsel? Learned counsel for the petitioner, Ms. Such and such is present. Stop. Learned counsel, Mr.
Jin Young Pom.
Ching Yung Pom, appearing for the Union of India, submits that the main respondent herein is the respondent number 2. Stop. Today, when the matter is called, none appears for respondent number 2. Stop. The learned counsel for the petitioner submits that a copy of the petition has been served on the standing counsel for the respondent number 2. Stop. You have enclosed the receipt in your petition. Have you enclosed?
No, Your Lordship.
Then in that case, how can we say that notice has been served?
Your Lordship, I have a soft copy with me.
You print it out and put it on record.
Yes, Your Lordship.
Stop. There is no receipt of notice on record as far as respondent number 2 is concerned. So the learned counsel for the petitioner submits that a copy of the same shall be provided on the next date. Okay, so list the matter after 1 week. Yes. A copy of the the trial court records have already been received.
For admission, item number 3.
Please, Your Lordship.
Mm.
I'm mentioning on behalf of my colleague in Nahoni Washa Lordship. I've been instructed that she is yet to file affidavit in opposition. So if Lordship may please release the matter after 5th.
She has already taken time.
Taken the counsel.
Yes, about 3-4 times she has already taken. Learned counsel for the petitioner is not present when the matter is called. Stop. Learned government advocate.
She has already taken the consent from the petitioners.
Okay. Learned government advocate, Mr. V. Jamomi, prays for 3 weeks' time to file the counter affidavit on behalf of the state respondents, on behalf of Ms. Inahuli, who's appearing in this matter. So it is submitted that the consent of the petitioner has been obtained. Accordingly, list the matter after 3 weeks in order to enable the government advocate to file the affidavit in opposition. Yes.
For orders, item number 4.
Yes, come. Not yet ready. Mr. Das, I'm told that it's not yet ready.
Yes, but
Okay.
before that, my lord,
Hmm.
if your lordship looks into the order that has been passed on 10/12/2025,
10-12 years.
please look into this order, my lord. If your lordship looks into paragraph 2, my lord, may I just read, my lord? This is an application on section so and so corresponding to so and so, question of an FIR of 11/10/2025 is registered at Dimapur Sabaran Police Station, case number so and so. It is submitted by Mr. Das, learned senior counsel, a case of the present petition or initiated a transaction of money in the year 2010 with one Arun Butoria who died in 2011, wherein there was a transaction of 5 crores. And as per statement in the FIR, all these transactions were in cash, and the present informant were assured that he would be paid 30% of profit for the said amount. The transactions were purely commercial and not a case of simple entrustment of property or money. Rather, it is a commercial transaction where it was promised to pay 30% profit to the present complainant. But from the money received, which was given a letter pad of the complainant, it reveals that the entire transaction was taken place in presence of one Pradeep Agarwal. And in the said letter pad, there is no mention at all
about the presence of the petitioner, who is stated to be one of the director of the company, namely Epcon. But the said Arun Bhutoria was not a director of the said company at the time of transaction of money, and what has been done was purely a personal transaction. Petitioner name was not even present at the time of transaction, but only for procuring money. The name the present petitioner along with two directors' name has been mentioned in the FIR. The entire transaction was completed in the year 2010, but after a long 15 years, the present FIR has been lost in the year 2025. The learned senior counsel further submitted in the year 2023, that is after 13 years, a GD entry was made, but it was kept in abeyance as some assurance was given from the accused person, and subsequent FIR has been registered only in the year 2025. Further, Mr. Das, the learned senior, submitted that these are all oral submission made from the informant, but there is no documentary evidence except the money received to substantiate the plea of the complainant that a transaction was completed in presence of petitioner who is one a director of the company, namely Epcon. Further, it is submitted as per one notice under section 35(3) BNLSS was stated to be issued on 14/10/2025, directing the present petitioner to appear before the IO on 31/10/2025. But the present petitioner never received a notice under section 35(3) of BNS, and he is present in the US after the miscarriage of his daughter, and since August 2025 he is in the US. But without even receiving a notice, an order of issuance of NPW was produced by the IO, and subsequently by order dated 2/12/2025, the learned magistrate has withdrawn that NPA which was issued earlier against the present petitioner. Further, citing the judgment of the Honorable Supreme Court in so and so, it is submitted by Mr. Das that there is no ingredient to attract neither section 406 nor 409 as registered against the present petitioner, and that the law clearly recognizes the difference between simple payment, investment of money, and entrustment of money or property. But here in the instant case, as it is seen from FIR itself, that it is what was a purely commercial transaction wherein the informant was assured to give 30% profit by late Arun Bhutoria. Thus, there cannot be any case against the present petitioner under section 406, 409 IPC. However, it is submitted by Mr. Das that present petitioner is still ready to cooperate with the IO in compliance with section 35(3) of BNSS, and he may be interrogated virtually as he is presently staying in US. Further, Mr. Das further submitted that no coercive action may be taken against the present petitioner as he is ready to extend his cooperation. So and so, the learned public prosecutor Nagaland has submitted case is still under investigation and his presence required, for which notice under section 35(3) BNS has already been issued against the present petitioner. But despite of notice issued, the petitioner is not cooperating with the IO, hence his physical presence may be required for the interest of the investigation. Considering the entire submission made by learned counsel of both sides, and on perusal of the case record perusing the case record along with the annexures and the petition, IO is directed not to take any coercive action against the petitioner. However, the accused petitioner hereby directed to extend his cooperation with the IO of the case. However, till his return from US, he may interrogate it or his statement may be recorded by IO through virtual mode. However, the investigating officer will also make an inquiry in compliance with section 35(3) of BNSS after his physical presence before the IO, preferably within the first week of February. Issue notice so and so, however, in respect of respondent number so and so, or scan copy of the case and list the matter again on 16(1). Why I read this order? Because if your lordship kindly see paragraph 8 and 9, the petitioner presently in US, your lordship has seen after reading this order that his daughter has given a stillborn baby. So that's why he has gone to US. And in the meantime, what he has been, the order of the court was that his statement we record virtually. Now we have sent an email. That's what we have brought an IA before the court. It has come to the court that an email has been sent. Kindly look into it. We have annexed the copy of the order. Where is it?
But this is not the court's copy.
Post copy should be some.
Hmm.
My lord, kindly see, I'll just give a copy to you. 1 second. Well, your lordship has read the order, which starts from page 12.
So it says that you have to be examined through virtual mode.
Yes, correct.
And then physically you have to come in the first week of February.
Now that's why I filed an IA before the court. Till today, we have written a letter, my lord, 2 emails. If your lordship kindly see at page 17. See page 17, my lord. Your lordship has looked into it. 10th of January, this we have written to them on 9th. I seen so and so right to receive follow up on my earlier request to email. This is the second email.
To record my statement.
See the paragraph 4, kindly see, my lord.
Paragraph 4 of,
paragraph 4
of
paragraph
your
4.
petition.
Yes, correct, my lord.
Of the IA.
Yes. My lord, as paragraph 3, my lord. Sorry, my lord. Paragraph 3 and paragraph 3, my lord. The applicant stated submitted after passing of the interim order dated 10/12/2025. Applicant wrote an email dated 16/12/2025 to the officer in charge Suburban Police Station along with a copy to Nagaland Police communicating the order dated 10/12/2025 passed in criminal petition that this honorable court has also requested for recording a statement through virtual mode as per direction of this honorable court. Now, 4, my applicant still submit as no reply was forthcoming from the police authority. The applicant again on 9/1/2026 wrote a follow-up, emailing requesting the officer in charge, Suburban Police Station Dimapur for recording a statement through virtual mode as per direction of this honorable court. However, till date, the filing of this instant application, no response was received from the police authority.
Okay.
Now this is what.
So what is your prayer here?
My prayer is that, my lord, my statement should be recorded in pursuance to the court direction. My lord, some type of investigation so that there is an advance. Secondly, my prayer again is been made that this daughter, because of daughter, that this time up to miscarriage, this time till first week of February may not be possible to return. So at least, my lord, my statement can be recorded.
Yes, PP, any instructions from the IO?
No, lordship. Still have not.
Can I
Whether he has received the email, anything? Because 2 emails have apparently been sent
Lordship.
by the petitioner and there's no reply, and he has not been examined virtually also as per the direction of the court.
Lord.
Hmm.
My lord, I will give a copy to my learned friend. At least he should also
Mr. Das, best thing is
he should also get a chance to take instruction.
You take it up on Monday.
No.
Yes.
Let him also contact the IO.
Lord.
Yes.
Let him give him a copy
I'll
of the
just give a
IA,
copy.
and then necessary orders can be passed on
Can
Monday
your
in the IA.
Yeah, correct. Can you
As far as this petition is concerned, we will just give some time.
Yes, my lord, can it be fixed on 19 so that your lordship, he can, in the meantime, my learned friend will give a copy to my learned friend. I'll give a copy to my learned friend so that he can take necessary instruction. And in the meantime, for passing necessary order can be fixed on 19. That's a better idea. I'm not troubled today
But
itself.
it is, we don't even know the number as yet. Anyway, we'll pass the order.
IA2, my lord.
IA2.
Two.
Okay.
IA2
First we will come. IA2 of 2026, okay. Heard learned counsel for the learned senior counsel for the petitioner, Mr. D. Das, assisted by Mr. I. Das for the petitioner. Also heard Mr. Veto Zimomi, learned public prosecutor for the state of Nagaland. So pleased on 19/1/2026 for necessary orders. That will be the IA. No, we'll just say necessary orders because another court will be there, so we don't know. Then no, the court will consider. Don't worry. We'll just say for necessary orders. Necessary orders, because I cannot say what the other court will say. That I cannot. And then No, wait, this will be the criminal petition. Then in the criminal petition, you say same, heard such and such. Then learned public prosecutor has prayed for some time to obtain instructions.
No.
So, list the matter together on 19, on 19, 1. The interim order passed on 10/12/2025 shall stand extended till the next date of listing. Yes.